Welcome to an oral argument session of the 5th District Court of Appeal. And we have one case on the docket here at 10 a.m. My name is Rand Wallace. I'll be presiding over this case. Also joining us from the 5th District is Judge Meredith Sasso. And we also have the privilege today of having Judge Michael Orfinger from the 7th Circuit joining us to helping us with these cases. And we thank him for taking time out of his schedule to do that. I just ask for everybody to make sure you have any devices that make noise, make sure you have those on mute. And probably the best practice is just to mute your microphone if you're not speaking at any time during the oral argument. I will assume the appellant, Mr. Sudbury, that you would like to have 5 minutes for rebuttal unless you tell me differently. The case is Tania Torriella versus Nation Star Mortgage. And with that, Mr. Sudbury, you may begin.
Thank you, Your Honor. May it please the court, my name is Adam Sudbury. I represent Tania Torriella and Luxury Living Developers Corporation. As is stated correctly in the appellee's brief, Luxury Living Developers Corporation has abandoned its appeal in this case. This case relates back to a mortgage loan from 2009. Very briefly, the procedural history of the case is that there were numerous attempts to obtain personal jurisdiction by service of process over the plaintiffs that all failed over the course of 10 years. Ultimately, the court entered final judgment under Rule 1.070J, dismissing the case for that failure. Ms. Torriella filed a motion to tax attorney's fees and costs, and that matter was decided against her in the lower tribunal. We've now appealed to this court to address that collateral claim. I would like to, unless the court has any specific questions about our argument to establish the attorney's fee claim, I would like to spend the balance of my time here addressing some of the arguments raised in the answer brief. Specifically, the appellee raises two arguments in its answer brief. First, that Ms. Torriella cannot be considered the prevailing party, and therefore fees cannot be awarded on that basis. And second, that Ms. Torriella has a bankruptcy discharge that converts the mortgage and the note into non-recourse instruments and therefore cannot be awarded attorney's fees under certain case law that applies to non-recourse instruments. I'd like to start with the second argument, and Ms. Torriella would argue that the plaintiff has impermissibly gone outside of the record on appeal in order to make that argument. There are only two places in the record on appeal, both cited in the answer brief, that they can point to as any factual support for this position. The first place that they point to is at the record, page 207, in an affidavit where Ms. Torriella states, quote, "I did file bankruptcy in 2010 with the Middle District of Florida," and cites a case number. And then they point to the underlying plaintiffs, an affidavit called the Affidavit of Diligent Search and Inquiry that reflects a bankruptcy search conducted in support of that affidavit. And they state in that affidavit that there was a bankruptcy discharge. The problem with those two places in the record are, number one, an underlying affidavit is hearsay within hearsay as to that specific point in contention and can't be considered substantive evidence. in support of that position. And number two, Ms. Torruella merely stated that she filed bankruptcy, which does not establish any form of bankruptcy discharge. There is nothing else in the record. There's no judgment in the record on appeal reflecting a bankruptcy discharge or what the terms of that discharge may or may not have been. And therefore, the plaintiff, or I should say the appellee, should not be permitted in this court to go outside of that record in order to establish this argument. The second point that they raise, which is really their first point in their brief, is that Ms. Torruella is not the prevailing party and therefore should not be permitted to recover attorney's fees under 57105 subsection 7. There is no dispute that there are two provisions in these instruments that allow recovery of attorney's fees, or at least allow the plaintiff to recover, or the appellee to recover its attorney's fees. That is in the promissory note at paragraph 7, subsection E, which states if the note holder has required me to pay in full, et cetera, they will have the right to be paid back by me for all of its costs and expenses in enforcing this note to the extent not prohibited by law. Those expenses include, for example, reasonable attorney's fees. And then paragraph 22 of the mortgage, towards the end of the paragraph, it states, lender, referring to the appellee or its successors, shall be entitled to collect all expenses incurred in pursuing the remedies provided in this section 22, including but not limited to reasonable attorney's fees and costs of title evidence. The reason I point specifically to the language of the two paragraphs is because when the court is determining whether or not to grant attorney's fees under 57105 subsection 7, it needs to look specifically to the provisions of the contract and what that contract says.
Mr. Sudbury, what was the remedy that your client received as a result of litigating the case?
My client received a dismissal of the case.
Okay, and was that dismissal of the case based upon the merits of the case?
Absolutely not. The dismissal is clearly without prejudice, and the plaintiff, to the extent not barred by the statute of limitations under the Bartram doctrine, would be able to refile their case. We fully acknowledge that.
And was the case refiled?
I don't believe so, Your Honor. On memory, I do not believe we're representing Ms. Torruella in a current action at this time for this property.
Okay, and ultimately, I would believe, and I don't want to put words in your mouth, but if the case actually, if there was service of process that was successfully served on your client and the case moved forward, then ultimately your position was going to be, I believe, that the appellee was not performing under the contract. Is that correct? The focus would be on the contract.
Well, we would have had to get to that point in the case. I wouldn't want to speculate what our arguments may have been if we had got to the point of filing a responsive pleading. Typically in these cases, we challenge, especially in cases like this one, we would be challenging the plaintiff's standing under some of these endorsements that are questionable. We would be challenging, the amount of the debt that's owed, and we'd be challenging the sufficiency of the acceleration provisions and whether or not a valid notice of default as a condition precedent was given under the terms of paragraph 22 of the mortgage. That's typically how these go, at least with my office. But in this case, we never got to those arguments because they never validly perfected service process.
And so in this case, the trial court had no jurisdiction over your client because there was a failure to obtain proper service of process. Is that correct?
That's correct. In the underlying case, that would be correct.
But yet your position is the trial court does have jurisdiction to enter a judgment for attorney's fees under the facts of this case.
Yes, Your Honor, and that is based upon the longstanding case law out of the United States Supreme Court, which was adopted by the Florida Supreme Court, that an action to recover attorney's fees is a separate collateral action and not part of the underlying cause of action, the underlying case. So when Ms. Torruella invoked the court's jurisdiction by filing her motion to tax costs and attorney's fees, that initiated a separate collateral action for which personal jurisdiction of her was certainly waived because she is the one that is filing that action. So the argument that the court lacks personal jurisdiction of Ms. Torruella is without merit because she was the one that was seeking the relief. So the personal jurisdiction of Ms. Torruella is never an issue in the subsequent collateral action.
And those cases, of course, stand for that there's continuing jurisdiction to decide an attorney's fees case or attorney's fees motion, not that the filing of a motion invokes the court's jurisdiction. Personal jurisdiction in Florida is still requires service of process, correct?
Yes, Your Honor, and I think it's important to.
And so, in prevailing on the service of process issue here, your client prevailed on a determination that the court lacked judicial power over her claim. Correct.
That's not correct, Your Honor. I think it's very important to differentiate between the two types of jurisdiction: subject matter jurisdiction and personal jurisdiction. So the court clearly has subject matter jurisdiction in this case.
And how is personal jurisdiction invoked in Florida?
Personal jurisdiction is invoked by filing an action and having the action served on the other party. That's how the court obtains personal jurisdiction under the long arm statute.
So it's your position that a motion for attorney's fees is an action for purposes of personal jurisdiction.
That's not my position. That is the United States Supreme Court and the Florida Supreme Court's position. They have clearly stated that a motion filed after judgment in the same action is a collateral action. It's its own separate proceeding. And the court has continuing subject matter jurisdiction to determine that collateral proceeding. So here we would be talking about whether or not the court has personal jurisdiction over the bank in that, and they clearly do because it's all linked to the original case. Once Tanya Torruella files that motion, personal jurisdiction of her is not.
Sorry, going back to the United States Supreme Court and Florida Supreme Court precedent, the cases characterize that as a collateral claim. Are you suggesting that a collateral claim and a collateral action are not legally? There's not a distinction legally and technically between a collateral claim in the context of an action and an actual action that would invoke the subject or the personal jurisdiction and the jurisdiction of a court.
It's our view that what they're saying is it's not something that needs to be raised other than as a matter of setting it forth in the pleading, the notice part of it. It's not something that needs to be raised as, a counterclaim or brought as some sort of third-party complaint in the original action. That it's separate and collateral to the underlying action and can be raised afterwards.
Because it's, so you're also suggesting that if it was waived subsequent to a dismissal of personal jurisdiction, that the movement would only be waiving it as to attorney's fees? In other words, you're not waiving personal jurisdiction as to the entire action?
Well, the action was dismissed. So if there were some sort of counterclaim or counter action, a motion that they could have filed for attorney's fees or something after judgment, then certainly they were free to do that, because once Tanya Torruella filed that motion, personal jurisdiction of her for anything after that was no longer a question. So
if that's the case, why could not the bank file a counterclaim against her to foreclose? I mean, one can't have one's cake and eat it too. You either
why could they not file a
jurisdiction or you aren't?
Well, because that's not permitted under the rules. The rules don't provide for relitigating the original claim post-judgment in the same case. There's also case law that talks about...
You're saying it's a different action. We established that the dismissal without prejudice. So it's a separate action, dismissal without prejudice. So if it is, in fact, a separate claim, a separate action...
What we're saying is it's a collateral matter to the original case. It's clearly in the same case, and the court has continuing jurisdiction flowing from the same case to determine that. But using the lack of personal jurisdiction over Ms. Torruella from the original case doesn't apply after she has filed her post-judgment claim in the attorney's fee subsequent to judgment. And Your Honor, if I may reserve the balance of my time for rebuttal.
You may. All right, Mr. Levine, you may proceed.
Yes, thank you. Good morning, Your Honors. Eric Levine on behalf of Nation Star Mortgage LLC. May it please the court. The court here should affirm the denial of prevailing party attorney's fees in this case. Ms. Torruella, who prevailed or obtained a dismissal for lack of personal jurisdiction, didn't prevail on any issue in the case, chose to preserve her personal jurisdiction defense instead of her obtaining her right to fees. The case law supported, the case cited by the trial court in this case, which is very similar to the issues we've already discussed this morning, is TBI Caribbean Company Limited versus Stafford Smith. And in that situation, the defendant, in the motion to dismiss for lack of personal jurisdiction, requested an award of attorney's fees pursuant to the underlying contract between the parties. The Third District Court of Appeals said that was because your request for fees was inconsistent with your personal jurisdiction defense, you waived the personal jurisdiction defense, which, applying the logical contrapositive to the issue before this court, you can have your personal jurisdiction defense, or you can preserve your right to potentially obtain fees under the underlying contract. But as Judge Orfinger put it, you can't have your cake and eat it too. You can't have both. And the federal courts in Florida that have looked at this issue, and I cite two cases in our answer brief, American Home Assurance Co. versus Weaver Aggregate Transport, and Flick Mortgage Investors versus Metropolis Promotion Investment and Properties. They address this issue head on, and they look at this and they say, if you obtained a dismissal for lack of personal jurisdiction, you haven't prevailed on anything. A dismissal, as the American Home Assurance Court said, a dismissal for lack of personal jurisdiction does not convert prevailing party status on any party. And that case cited to a previous US Supreme Court case, which basically said a party must obtain some relief on the merits in order to be a prevailing party. If Ms. Torruella had prevailed on us failing to send a breach letter, that would be prevailing on the merits. If she was able to show that we lacked standing, that she wasn't in default, all that goes to the merits. However, when you come into court and say, I haven't been served, you have no jurisdiction over me, which is what the court in this case agreed with her on and dismissed the action against her on that basis, that's the end of you in that case. you can't turn around and then say, well, now I actually am, now that I prevailed on that issue, now I'm waiving jurisdiction and now I want my fees. So the case law in Florida has been pretty much unanimous against it, both in the federal level and the state level. And I think for good reason. Switching arguments because it's more convenient to you after you got the case dismissed isn't really favorable, not really looked well upon.
And what is your response to the argument that attorney's fees is a collateral claim and therefore she can waive jurisdiction for the sole purposes of attorney's fees in the context of original action?
Well, Judge Nassar, you already addressed that. Exactly what I was going to say. Those case law, I think it's the Heineken case. No, sorry, not the Heineken case. It was the Martinez versus Giacobbe and Finkelstein versus North Broward Hospital. That has to do with case jurisdiction and continuing jurisdiction. So before the adoption of Rule 1.525, if a case was dismissed, final judgment entered for one party or the other, and there was no reservation of jurisdiction in the final judgment to award fees, you might run into the problem the court no longer had jurisdiction to award your attorney's fees. To get around that problem, the court said, no, that's a collateral issue. The court has continuing jurisdiction to address that as long as your motion is made within a reasonable time, which later was subsumed into 1.525 with a 30-day bright line rule. So he's confusing case jurisdiction with personal jurisdiction. Once she prevailed on personal jurisdiction and said, this court has no power over me, you don't get to come around and say, well, now that it's better for me, I'll waive it. So we never disputed the court's case jurisdiction to hear the motion. That's collateral, that's perfectly acceptable. But because she prevailed on personal jurisdiction on the merits of the motion, she's not a prevailing party entitled to fees. The second problem is the bankruptcy discharge. Now, counsel didn't file a reply brief in this case, so the argument he made is not actually before the court in any paper, but I will want to talk about that. Mr. Torello's counsel forgets, and it's a glaring omission, but he forgets that not only did she move for prevailing party fees before the trial court, which is what we've been discussing, she also moved for prevailing party fees before this court, invoking this court's original jurisdiction to grant fees in this appellate proceeding. And we did, in opposition to the motion before this court, provide a copy of her petition and provide a copy of her discharge. All those documents are properly before the court under Rule, I think, 9.300 governing motion practice. And counsel never, other than his waiver argument, which should not be well taken, he never addressed the merits of the motion. It can't be disputed under the record before this court that Ms. Torello filed bankruptcy in December 2010 under Chapter 7 and obtained a discharge in March of 2011. What happens when a borrower obtains a bankruptcy discharge like this? Their personal liability under the note disappears. There's a permanent federal injunction against it, which is still in place to this day. By doing so, she transformed her loan with the proverbial wave of a bankruptcy judge's magic pen, and it became non-recourse. That means NationStar, even Judge Wallace, as you pointed out, maybe we will refile in the future. Even if we refile in the future, we could never, under any circumstances, get a money judgment against Ms. Torello for our attorney's fees. It's legally impossible with that discharge in place. 57-105 was designed to even the playing field. Every party has the same rights. So Ms. Torello, armed with a bankruptcy discharge, says, the bank can't get their fees against me, but I want to get it against them. That's not permissible. That goes beyond what 57-105 was designed to do. And I'll use the colloquial, what's good for the goose is good for the gander. If she has no problem discharging her personal liability on these loan documents for any attorney's fees we incur, she has to recognize that any personal liability the bank might have for her fees is also discharged. And that is what the case law says, undisputed in Florida, that if a lender can't get their fees against the borrower can't get their fees against the lender. With that, Your Honors, I know I still have 13 minutes left, but unless the court has any questions, I'll rest on my briefs and the argument. I ask that the order denying the motion for fees be denied, and I also ask that the pending motion before this court for appellate attorney's fees also be denied.
Thank you, Mr. Levine. And Mr. Sudbury, you've got a little less than 4 minutes to go.
Thank you, Your Honor. One issue that I really do want to address with the court is the appellee states in his brief, and I believe that he is correct, that this issue of whether or not prevailing party, quote unquote, prevailing party attorney's fees can be granted following a dismissal for lack of personal jurisdiction appears to be one of first impression in the Florida state courts. So if this court does address that issue, it does appear to be one of first impression, and we would urge caution in establishing a rule that such a dismissal is not a dismissal that would allow for those fees. He is correct that there are federal courts that have addressed this issue. However, those federal courts, the cases that he has cited, that the appellee has cited, are not directly on point, and they discuss statutes that award attorneys fees, such as under Unfair and Deceptive Trade Practices, Uniform Trade Secrets Act, and the one case that is somewhat analogous is Religious Technology Center versus Liebrich. This is 98 Federal Appendix 978, where that court, in considering the argument, pointed very directly and specifically to the provisions of the contract, making it clear that it is very important to do exactly that and to refer back to the contract and to read exactly what the contract says about the fees that are allowed to either party when deciding whether it can be shifted under 57-105. So in that case, the reason that it was denied was because the contract stated specifically that it required a breach of the agreement to be established, and that under the circumstances in that case, there was no breach that could be pointed to or established in the case in order to trigger that provision. What we believe is most analogous under that prevailing party language to this case is the jurisprudence out of this court and other Florida courts that state that a voluntary dismissal is a determination for purposes of prevailing party to recover attorney's fees under 57-105 subsection 7. And the reason why it's most analogous, and the court should really look at the voluntary dismissal jurisprudence, is because a voluntary dismissal, when one is taken, especially in a mortgage foreclosure action, operates as an adjudication, not on the merits, but they can take one without prejudice. So it is a dismissal without prejudice in the same way that a 1.070 dismissal is without prejudice. So a voluntary dismissal.
Doesn't Rule 1.070J specifically say that it is not, dismissal under that rule is not considered a voluntary dismissal under Rule 1.420?
Yes, Your Honor. And may I continue past my time strictly to address the court's question?
You may.
It says that the reason it says that, Your Honor, is to make it very clear that the plaintiff still has the right to take one of its free voluntary dismissal, and that dismissal would not trigger the second voluntary dismissal, which is with prejudice. So that's the reason it makes it clear on that ground. Not that, but the first voluntary dismissal under, I want to say it's 1.420, is clearly without prejudice, just in the same way as a dismissal, any dismissal under 1.070 would be without prejudice. And with that, the appellant would rest its case before this court.
Okay, thank you, counsel, for your argument. Thank you, counsel, for your arguments, and we are in recess. Have a nice day.